Morning, everyone. Thanks for that welcome. I'm not as tall as Grant. Good morning, everyone, and welcome to our Making Strata Better community information session. It's great to have you here today, and really pleasing to see the turnout and seeing that so many people share our interest in making Strata better. My name's Graham Gamion. I'm the Chief Executive of Landgate, but before I get started, I'd like to respectfully acknowledge the traditional owners of the land we're meeting on today, the Whadjuk Noongar people, and pay my respects to their elders past, present and emerging. So first, I'd just like to start with a little bit of background about Landgate. So who are we and what do we do? Well, Landgate is Western Australia's Land Information Authority. We deliver location information, property valuations and land titling services for the state. As part of our work, we are also responsible for the Strata Titles legislation on behalf of the Minister for Lands. I might make a slight departure from the notes here. You may have noted in the media in the last week or so that there's been mention of a substantial transaction involving Landgate. Just to let you know what that's all about is that Landgate has entered into a 40-year contract for a service provider to look after our information technology systems that support our land registry. For the privilege of doing that, the service provider has paid us about $1.41 billion in advance, and we'll be sharing our revenues going forward. What does it mean for everyone in this room? It means no change whatsoever. The current services that you receive from Landgate will continue unchanged, and Landgate will continue to cover off its responsibilities and produce the work that it has done years gone by. So literally it's a back-end change that won't affect anything you see or hear from Landgate. So I hope that clarifies that a little for you. Now, coming back to Strata Titles, the amendment legislation was passed by the Parliament late last year. So in effect, the Parliament has already decided how Strata Title matters are to be taken care of through the legal system over the next period until the next review of the Act, as it may be. Now, since that time, we've been working with stakeholders across government, industry and the community to draft the associated regulations, and these were released for public consultation last week. Now, this overview session will provide you with a high-level summary of the key changes to WA strata laws to help you understand what they mean for you, whether you're a strata owner, a tenant, a manager or a property developer. Now, this first session will take about 45 minutes, after which time we'll have a 15-minute panel discussion to address some of the most common questions Landgate has been hearing from the community over the last 2 weeks. Just so you know, Landgate has been consulting right across the state, from Karratha in the north to Bunbury and Busselton in the south and out to Kalgoorlie. And we've also been running sessions like this across the metropolitan area over the last week. So we've heard a lot, and we'd like to share with you what we've heard from some of those consultation sessions so you get a sense of what others are thinking as well. Now, following this session, there'll be 5 focus sessions that detail the key changes throughout the rest of the day. Now, please feel free to join in any of those sessions if you'd like more detail on a particular subject, and I'd encourage you to do so. They will, however, be recorded, so in the event that you can't stay for the day, you will be able to get onto our dedicated website, strata.gov.au, to have a look at those sessions so you can review them again later on should you choose to do so. Now, the Strata team will also be available after this presentation to chat if you have further questions. So there is a team of people here. Perhaps I'll get them to show their hands. There's the wonderful team, 2 at the back, 3 down here. So there's plenty of people here for you to have a conversation with if you've got particular questions you'd like to follow up. And lastly, after you leave today, our customer service team is at the end of the phone for you. So again, pick up the phone and have a chat if you need any further information into the future. So let's just have a quick look at the Strata in WA, just a very brief look to set some context here. Now, the existing Strata Titles Act was created in 1985, so it's been around for a long period of time without a lot of change. Now, of course, it's a very different world in 1985 to the one that we live in today. Just a couple of statistics for you to get a bit of a sense of that. The average Australian salary in 1985 was just $19,000, and the average house cost about $150,000. I'm going to give my age away a bit here, and I bought my first house in 1985 for $54,000, so about a third of the average. I was a bit poor then. Today Strata is growing form of land title. More than half of new land subdivisions that are happening across Western Australia are in fact strata title. It covers residential homes, units, apartments and townhouses, as well as retail and commercial premises. It has a very broad reach. Now, last year, strata properties to the value of $11 billion were sold, and these are remarkable figures when you think about it. Now let's get a sense of the strata community as, in the room today. So it's a participation section, everyone. I was wondering if you could put your hands up if you are an owner of a strata lot or strata lots. Wow, that's great. Thank you and welcome. So how many of you live in a strata? Good numbers again, terrific. How are you feeling? A bit of exercise, that's all good. And how many of you are on a strata council? Wow, that's fantastic. All right, you're very special people that take a very close interest in this stuff. For those of you who are owners, your property is one of about 320,000 lots across the state. 80% of those are located in the Perth area. So it really is fantastic to see so many of you here today to gain a clearer understanding of how the reforms will improve the way your scheme works. So let's just take a quick snapshot of strata. Here we have a snapshot of what strata looks like across the metro area. The areas listed, the 10 local governments with the highest number of strata lots across the metropolitan area. Now, what's quite interesting in these figures, but perhaps not surprising, is how the ratio of lots to schemes varies quite dramatically depending on where you are. For example, you can see despite having 18,000 odd lots, the City of Perth has only 704 schemes. This shows that on average a scheme in Perth has an average of 26 lots, which is the greatest density of anywhere in the metropolitan area. Perhaps not so surprising when you just look to the east of us here and how much development has happened in recent years. Now this is compared to Melville, which is just across the river there, which only has an average of 3 lots per scheme, so obviously a much lower density. But again, I think you can see with the changing skyline on the southern side of the river there, that's going to change quite rapidly in the coming years. Now, of course, Melville's average lot reflects a greater number of small schemes such as duplexes and triplexes. Many people aren't aware that most duplexes or 2-lot schemes are actually covered by the Strata Titles Act, so it's actually something to be mindful of. Now, the contrast between Perth and Melville is a reflection of the diversity that exists in strata for Western Australians. And it shows that living in strata isn't just about living in high-density apartments by any means. So just reflecting now on WA's new strata laws, as the state's population continues to grow, so too will the number of strata lots and schemes. An update to the current Act was clearly needed to better support the large strata community and meet their expectations of what modern strata arrangements should look like. There was also a consistent desire across the community, industry and government for a much clearer and fairer set of laws to guide WA's strata system. Now, WA's 2 new strata laws were passed by the Parliament last November, so that's set the framework for our discussion today. The first of these new laws comprehensively amends the existing Strata Titles Act of 1985. So the Strata Title Act of 1985 continues on, but it's been amended by the Act that went through late last year. This new law and the regulations which will accompany it are what we're focusing on today. The changes we're making to strata will affect a wide range of people, professions and industry in WA, including strata owners, managers, tenants, property developers, planners, potential buyers of strata and many others. While the detail will be discussed shortly, some of the key changes include better information for strata buyers. It's a rather large investment, as everyone in this room will certainly know, and being as informed as possible is really important when you're buying into a strata community. There'll be more efficient processes for resolving strata disputes. No one likes a dispute, but it's also always comforting to know there's somewhere you can go to get these things resolved, and the current system is very complicated, and that's being refined down to a one-stop shop. And extensive improvements to how strata schemes are managed as well, which is a really critical factor. These, particularly, or really any built form these days is a complicated structure, whether it's a single unit through to a large apartment development. These are things that need to be cared for and looked after, and can be more and more challenging as scale increases. Now, these changes will be valuable in optimising large-scale developments. So, pardon me, I've skipped a paragraph. The second new law is the Community Titles Act, which will introduce community titles to WA as a new form of land title. These titles will be valuable for optimising large-scale developments, and they'll basically enable structured development over time rather than having to do a strata for the development right from the outset, which would be quite beneficial for that larger scale stuff. Community titles is something that will gain more focus next year. So today we're talking strictly about the amendments to the Strata Titles Act and the regulations that will support that coming into to law. Next year we'll be focusing on community titles as a new form of land tenure. Now, the regulations compared to law. So talking government speak here, it's easy for us public servants to understand what it's all about. For those of you who are new to this stuff, the new Strata Regulations are what is now available for public consultation. They are what's needed to make the new law effective. So although the Parliament passed the law last year, the regulations are essential to bring that law into effect. They set out how people are required to comply with the new Strata Act. That guides us on what to do. So if we think about it through those terms, the legislation tells us what to do, the regulations tell us how to go about it. So how do we do it? Now, the timeline for change. So the amendments aren't law until the regulations are passed. So the regulations are available online now at strata.wa.gov.au for anyone to view and comment on until the end of this month. We've been running these community information sessions since early September, as I mentioned, across regional centres and Perth's highest density strata areas to help people understand the detail behind the changes. In October, Landgate will review all feedback received from the community and deliver the final set of regulations to the Minister, who will offer them to the Governor for his consideration, then finally the Parliament, hopefully towards the end of the year. Once they're in the hands of Parliament, it's up to them in terms of how quickly the regulations progress. Now, these changes are the most significant reform in the WA Strata framework in over 20 years. And I believe that our extensive consultation over the past few years has helped us to ensure that they are meaningful and effective. Having said that, these sessions and this period of time is about hearing from the community to understand whether we've got the regulations right. So we do want feedback at this point in time. So that there's still opportunities for us to continue to refine those before they progress to the Minister and the Government and the Parliament. So I really encourage those of you that are interested in looking at the finer details to examine those regulations. There's only about 150 pages, so it's modest. But I really do encourage you, if you do have a serious interest, please have a look, because this is about how we manage our stratas into the future. So please have a look, and please give us your feedback. That's really critical to us to help us refine the regulations and to help us assure both the Government and the Governor and the Parliament that we have consulted broadly and taken that feedback on board. Now, that's enough from me. I'd like to hand over now to Glenda Kirby, a Strata Reform Analyst and a long-time Strata owner herself and occupier. Glenda has been working on these reforms for over 5 years, so what she doesn't know is not worth knowing, and we'll take you through these key changes. I do hope you find the session useful, and thank you very much for being here with us today. Thank you.
Thank you, Graham. I can see some repeat offenders. I've been giving this talk for the last week, and I'm recognising some faces. People are coming back for more. I'm not sure if that's good or bad. I'm going into the detail of what's changing. Graham has given you an overview of the overview, but there are 7 main topics that are changing. and I'll be giving you, as I said, the overview. Hands up those people who are going to the more detailed sessions later on. Okay, that's great. If you find that in my overview you want more detail, then just stay back for the detailed sessions, because they'll be given by the legal team that know all the words like forthwith and aforesaid mentioned, and they'll be going into a lot more detail. So the first topic we've changed is better buyer information. Now, as Graham said, I was one of the few people on the Strata Titles Act reform team who not only owned a strata but lived in one. I had felt the pain and I had flesh in the game. When I bought my strata, I knew it was, you had strata bylaws and things like that, but I really had no idea what I was buying into. The reforms we're bringing in will provide a lot more information for people who are buying their strata scheme. A strata is a small democratic community with its own laws, finances and voting procedures, and it's very, very important to know what your scheme or the scheme you're looking at buying into is like. So the first thing that people will be given is a copy of the scheme bylaws. This isn't new. You always got your scheme bylaws, and they're essential to read before you sign up for a strata scheme. Your scheme bylaws might prevent something like putting a Foxtel dish on your roof or smoking. So you buy your lovely townhouse and then you find you can't smoke and you're an addicted smoker. It could end up in tears. So the bylaws are very important to read. And as I said, this isn't a new requirement. This has always been needed. The next thing is a copy of the scheme notice. Now, the scheme notice is a new document and it gives you the name of the scheme, the address for service, things like that. But it also will indicate on it whether or not your scheme is a leasehold. Now, leasehold schemes are new and it's essential that you understand what a leasehold scheme is. I'll be covering it at a high level, and later on the legal eagles will be doing it at a much more detailed level. The other thing you'll receive is a copy of the minutes of the last AGM. Now, those people who live in a strata and are active in their strata know that very often an AGM will reflect if there is any conflict in a scheme. So you will see by the minutes if there was a lot of contention around motions and that sort of thing. It's very important to tell you what the nature of the scheme is. Along with the AGM minutes, a copy of the strata accounts is required. Now, this is for the bigger stratas that keep accounts and have AGMs, not for the smaller ones. But the strata accounts are enormously important in that they will tell you how much finance there is in reserve. So is the scheme being run on a very lean budget, or is money being put aside for future maintenance, future problems in the scheme? If not, then warning bells should be going off. If you're buying into a survey strata scheme, there is less common property than if you're buying into a strata scheme. Who knows the difference between a strata scheme and a survey strata scheme? Hands up. Quite a few of you, well done. Oh, you've done your homework, I'm impressed. You two know because you came to another session. A strata scheme is generally, and we're talking in generalities here, there's always an exception, where a building has been subdivided. So the unit you're buying is within a building. And in most instances, you don't own the walls or the roof. The building itself is common property and will be maintained by the scheme. So the money you put aside in your levies goes to maintain the actual building you live in. A survey strata scheme is more like a land subdivision. The boundaries are determined by a surveyor and you either build your own building on it or a scheme developer puts the building on which you own. It's much more like a freehold title. So in those instances, there's sometimes no common property, but more often just common property, which is the driveway. So you don't have to have $20,000 in the reserve fund to cover contingencies because, you just relay the bricks. So that's important to understand. You'll also be given a plan of your strata scheme with your lot marked on it, or the lot you're interested in buying, and there is a lot to know on the plan. It's essential that you keep your plan because it tells a lot of legal stuff as well as just what you're buying. You'll also get a chart of unit entitlement, a schedule of unit entitlement, which tells you what proportion of the common property you own and therefore what proportion of the expenses you have to cover. And you get that now. What you don't get now is an estimate of what your levy will be. And the levy is determined in the AGM by the other owners in the strata. And some levies are much higher than others, and that will depend on not only the type of scheme you're in, but how well maintained it is. So you need to look at that to find out if you can actually afford to live in this strata. If you're buying off the plan, in other words, you can't see the lot and there isn't a title yet, there are extra information items that you're given so that you know exactly what you're getting into, and it's important. This means that before you put in an offer on a strata lot, you'll get a great wodge of documentation and you look at it and think, oh no. You don't have to read it, but if you don't really know what you're buying. So that information is there now for you to make sure you absolutely know what you're buying. We're protecting the buyer. In the instance where you've been given information and that information changes between the offer and settlement, you are required, the seller is required to provide that fact to you. If they don't, and it materially prejudices you, that's a legal term, I've learnt that, you can void the contract. So it's very important that you know what's going on. Now, that is all detailed in Part 10 of the Act, which, as Graham said, is cast in concrete. It's been passed by Parliament, but it's also in Part 13 of the regulations, and that's what we want feedback on. If we have covered enough areas, it will be detailed in Part 13. So that's your homework, feedback on Part 13. So moving on to strata management. We all love our strata managers. Any strata managers here? Oh, I better be nice then. Okay. Poor old strata managers. They weren't even mentioned in the old version of the Act. So how could anyone know what they were supposed to do as a strata manager, and how could strata owners know what to expect of their managers? So now the Act has been changed to provide a lot more clarity around the role of the strata manager, and also that gives clarity to strata owners to know what they can ask for. There now is a solid framework of responsibility for strata managers, and it guides the managers as to what they should and shouldn't do. It details the general duties of a strata manager and how to handle a conflict of interest. There are minimum requirements for management contracts, and every strata manager must have a management contract with the strata company, and volunteer strata managers must have a contract with the strata company. There's a need for both volunteers and professional strata managers to disclose commissions and benefits. So anything that they're benefiting because they're running your scheme, they have to disclose that. There's also details for them on how to run the strata accounts and what type of accounts, bank accounts, must be trust accounts, that they keep your money in, so that you know your money is covered by a trust at all time. There are also minimum education requirements needed for strata managers. And we're not going to hit everybody with this instantly, that everybody has to have a Cert 4 in strata management, but over a period of 5 years this will be phased in, so that you will know that the person you're speaking to when you phone up with a query about your scheme will at least know how to read a strata plan, which is not an easy thing to do. It's quite, you have to do a unit to learn how to read a strata plan because they're quite complex, and that's the sort of service a strata manager will provide. Now, the Act does not require strata managers to be licensed. Parliament considered this and decided that there wasn't enough information available for them to make a decision on whether or not to license strata managers. One of the issues that was brought up was that the extra cost of licensing would impose that extra cost on strata owners. They would pass the cost on, which they're quite valid in doing. So what we've decided to do instead is to require strata managers to, once a year for the next 5 years, provide data to Landgate to inform us as to how many schemes they're running, the different sizes of the schemes, how much money they're holding, and whether or not their staff is taking up education qualifications as required. Once we have that information, we can then make the decision on whether or not licensing is a valid way to approach strata managers. Meanwhile, we have provided the tools for strata owners to take it into their own hands if they feel that the strata manager is not complying with their contract. That contract can be terminated. And if they feel a strata manager might have nicked off with the funds, then there is the ability to go to SAT and get retribution straight away. So it's probably a faster process than if the strata manager was licensed. Okay, dispute resolution. Now, all you people who live in strata, you know there's no such thing as disputes in strata, don't you? Everyone gets on so well. You never have that one person down the back who says no to everything. Yeah, okay. Currently, when you have a dispute within your strata scheme, there are 4 different areas covering those disputes. You might go to the district court, or the magistrates court, the Supreme Court, or the State Administrative Tribunal. It's very hard to determine which jurisdiction you will be required to complain under. And very often I've heard of instances where people will actually turn up to, say, the district court and find out that no, it's the wrong court. You have to go to another court, which means that there are delays, extra expense of having lawyers, and so on. So what has been proposed and cast into law is now that there is one-stop shop for strata disputes, and that's the State Administrative Tribunal. So SAT will become your first port of call in all strata disputes. It's worth going to the SAT website. It's a very well-designed website. It's up there somewhere, sat.justice.wa.gov.au. And they describe there how they operate. To quote the website, the benefits of SAT include creating less formal, less expensive and more flexible procedures than used in traditional courts, and to provide a more appropriate and timely means for citizens to obtain administrative justice. I still am, on my strata council. An owner took us to court because we weren't reacting to him quickly enough in his opinion. So he took us to SAT. We went to SAT and it was one of the most enlightening experiences I've had. It was brilliant. We sat down with one of the SAT members and he facilitated conversation between the parties. It cost $100. It was over and done with in 2 weeks. The process had started that conversation and the dispute disappeared. It no longer existed. Everyone had talked it out. How many times in a strata is there a dispute which, because of the cost of going to a court and having to employ a lawyer, everyone just rolls over and plays dead, basically. And that dispute lingers on. That feeling of discontent within the strata lingers on. Doesn't have to be like that anymore. You can go straight to SAT, and SAT is eminently sensible. It's a people's court. It's the right way to go, and it's a fantastic advance in strata living. Debt recovery, which is the recovery of levies or expenses that people aren't paying, is still handled under the district court, I think. So that hasn't changed because it's just a straight debt recovery process. It's not peculiar to strata. So that's worth noting. Okay, bylaws. Now, it's not accidental that the topic of bylaws comes immediately after dispute resolution. The strata rules by which it runs impact owners, occupiers, strata managers alike, and there's little understanding of what's involved, and some of them are very, very complex. So the standard bylaws, which are those set out in the Act, which in the old Act was Schedule 1 and 2, have been quite extensively changed. Now they are still called Schedule 1 and 2, but they are called Schedule 1 Governance and Schedule 2 Conduct. So it's very obvious what each set of bylaws is doing. One is governing the scheme, how you vote, how you run the scheme. The other one is conduct, which is how you behave in the scheme, where you can park, can you let your dog run on common property, that sort of thing. So it's made it easier with that. Some of the existing Schedule 1 bylaws have been removed. They've been repealed from the bylaws and they've been moved into the body of the Act because they govern how meetings are run, how voting is conducted, and it was felt that it wasn't appropriate to allow individual schemes to change that. Voting and running of AGMs is standard to everyone now. There is no variation. The other bylaw which has been removed is from Schedule 2, the conduct bylaws, and it's the one, I don't know if you've come aware of it, but there's one about children cannot play on common property without the supervision of an adult. That's gone. That was considered discriminatory, and now discriminatory bylaws are illegal. You can't discriminate against specific people in your bylaws. The other thing that you can't do in bylaws is prevent assistance animals. So guide dogs, hearing dogs, I don't know, any other assistance animals, registered assistance animals, cannot be prevented from living in a strata or visiting a strata. So that's quite important to know. The other thing that is coming in is the ability to lodge with Landgate consolidated bylaws. Currently all your bylaws are in different documents held by Landgate. It can be very confusing to try and get all the bylaws for your scheme. They will now be consolidated, held in one place and easy to access when disputes arise, which of course they don't. Okay, termination. The termination provisions in the Act are in Part 12 and Part 14 of the regs. No matter how you dress it up, winding up or terminating a scheme is a big undertaking. In the residential world, we're talking about people's homes, and it's essential that fairness and equity are paramount. There are many reasons you might want to terminate a scheme. Older schemes may have reached the stage where it just isn't worth maintaining the building, and people are finding that it's too expensive, they can't manage the levies. It might be a good idea to terminate that scheme, sell things off and start again. There are schemes now in areas where the R code has changed, where you can put more density onto that land, so that the underlying land that your scheme is on is actually worth more than your scheme. And it might be worth everybody's while to sell up and make a bit of money and move somewhere else. There are also areas where planning has changed, which enables current strata properties to be subdivided into freehold, so green title properties, and that would require a termination too. The city's growing and commuting times are getting worse. People want to live closer to the CBD, and where a strata property is to be redeveloped, it must first be terminated. But as I said, this termination must start of the existing scheme in a fair and equitable manner. Okay, there are 3 steps in the termination process. I'll cover this at a very high level because the detailed session will go into the detail, quite obviously. So the first step or first stage is for the proponent, that's a big legal word for the guy who wants to terminate the place, and that person must be an owner or have put in a bid on a property, so he is going to buy a property. That's essential. The proponent can't be somebody from across the street. The proponent puts forward a proposal to the strata company, that's to all the owners, with the idea, just the idea, and people will vote on that. Now, if the majority, of 50% of the owners say, well, yeah, this looks pretty good, let's go ahead and give us the detail. Stage 2 is that detail, and boy, is it detailed. the proponent has to provide all the information that you are likely to need in order to say yes or no to this termination. And that includes things like the contracts that each person, each owner will be provided in the proponent buying them out, if that's what they're going to do. It will also include the funding that the proponent has to provide in order to help you understand what's coming. The strata company will provide an independent advocate to assess the report, to evaluate it on your behalf, and to complete a report for you, the owners of the strata company, and then also to stand up and give a presentation about that. The independent advocate will also determine if anyone in the scheme is vulnerable, and in the regulations, vulnerable is defined. And we're talking people who perhaps English is a second language, or they're deaf, or there's some other reason why they can't make that big decision on their own or without help and guidance. So at the end of that time, the strata company vote, and if more than 80% or more of people want to terminate, but not 100%, then it will go to be confirmed by SAT. SAT will evaluate the pros and cons. If it's unanimous, straight through to termination. The scheme will be terminated, complying with the guideline or complying with the contracts and so forth in that report. So the third step is where SAT will evaluate the termination and decide whether the termination should go ahead, whether it should go ahead with changes, or whether it shouldn't go ahead at all. And it will take into account all the vulnerable owners. It's important to remember that if you're in a scheme of less than 5 lots, so that's 2, 3 or 4, the termination must be unanimous. Everyone must agree. Okay. So the outline proposal, as I said, will give you an overview of what is actually being proposed, whether the proposed development complies with planning guidelines, what the detail of the funding is going to be for the next stage, and it's voted on as a simple majority. There is a streamlined process. If everybody in the scheme already knows that they want to terminate, it's unanimous, then you can streamline it. We don't have to go through so much detail and so much expense. Step 2, the detailed proposal, will include a plan of subdivision. So it will be approved by the WA Planning Commission. So you know it will go ahead if the termination is completed. There are full contracts of sale. There are contracts under which the owner may acquire part of the land, or there might be a like-for-like exchange if the developer is going to build units on the same land. They might be prepared to offer you a unit in exchange for your existing unit. There will also be a termination infrastructure report, which looks at your existing buildings and assesses whether or not they can be fixed up, if that's the issue. There'll also be a sworn market valuation for your property. So the property it's a sworn valuation by an independent valuer to give you an idea of, if you were selling on the open market, what you would be getting for your property. The independent advocate comes in here when he speaks to the scheme owners to tell them what is really being proposed, and then the final vote of 80 to 99%. So if 20% or less owners dissent, say no, they don't want to terminate, the termination will move on to SAT as the third stage. And SAT will hear from all the proponent and all the dissenting owners as to why they're dissenting, what's driving them, what's their problem, that sort of thing, and we'll make a ruling at the end of that as to whether or not termination goes ahead. I'm sure you've got lots of questions about termination. Hold them over for later on in the detailed session, where there'll be even more detail as to what has happened or what will happen. Okay, stage subdivision. Does anyone live in a subdivision that was staged, a staged strata? Okay. What it means is that the scheme is developed over a period of time. So a developer may not have enough finance to develop the whole scheme in one go. He might put up a single high-rise, sell that off from that finance, then develop the high-rise next door, and so on. That requires him to tell the owners that sign into the first building, exactly what is proposed for the next one. In order to do this, the way he does this currently is through a management statement. That has been changed to now be called staged bylaws, and the staged bylaw must tell you all the detail of what is proposed for the next stages. This photo here, I don't know if you can see it, is a real stage subdivision, and it shows it really clearly. The first two buildings are complete. The next building is in the process of being built, and the final building is just the foundations. And that's the way it goes. So the owners of the first building knew they were going to be living next door to a building site for quite some time, but they knew that the end plan, they knew what it would look like and what it would involve. So of course, economics change over time. The developer may find that the size of townhouse or unit that he's building is not appropriate for the market now. They need to be bigger, or they need to be smaller. Or planning bylaws change, which may mean they need to provide more parking spots, so they're going to have to put an underground car park. Things like this change over time and will force the developer to change what he's planning to do. When this happens, he has to go back to the owners of the first building and get their permission to make these changes. The new regulations are much clearer in what those changes can be. They used to be called non-minor, love double negatives, a non-minor change. Now they're significant changes. So if a change is significant, the developer must go back to the owners in the first building and get their permission. Now, part of getting the permission also involves getting the permission of their mortgagees, of the banks and caveators and any interested parties or designated interested parties, it says. In the past, this has been problematic. A bank will get a letter saying, will you approve of this, and lose it. And in the past, some developments have been held up for years because of designated interest holders not being interested or saying no for no particular reason. That won't happen anymore, because that meant that those people in the first building were living next door to a building site for years when they thought they were going to have nice neighbours. So what happens now is those designated interest holders will be notified of the changes in the development, and if they don't respond in 60 days, it will be deemed that they've consented, which makes life a lot easier for everyone living in a staged development. Okay, now we're moving on to leasehold. Leasehold is a bit of a misnomer in that it's not exactly like as if you were leasing a property now. It's more like freehold with a use-by date. So you will hold a title if you buy a leasehold. It'll be a title. You can sell the title. You can buy another one. But that title is only valid for a specific period of time, and that period of time is anywhere from 20 to 99 years. So when it reaches expiry, if you've bought a leasehold lot, in a leasehold strata, and you've owned it for 99 years, at the end of 99 years, you won't own anything. It will go back to the owner of the underlying land, who we refer to as the owner of the leasehold scheme. It sounds strange, but it happens in other parts of the world. We didn't invent this. One of the places that we corresponded with to find out how they'd managed it was British Columbia, who also work on the Torrens system. And in British Columbia, there's specified areas of land, one of them being central Vancouver, where it's only available in a leasehold, as a leasehold scheme. Interestingly, they are now getting towards within 30 years of the expiry date, and some of this land, magnificent houses overlooking Vancouver Harbour. So we are watching that with interest to see how they handle that extension, or what they're going to do with their leasehold land. So you own the leasehold lot, but the owner of the leasehold scheme, the guy who owns the land underneath, has a reversionary interest. Now that's legalese for he gets it back when the lease expires. we anticipate, we can't predict it definitely, but we anticipate that a leasehold strata lot will be cheaper than a normal strata lot when the leasehold term is shorter. So if it's a minimum term, which is 20 years, you're obviously not going to want to pay as much as if it was 99 years. 99 years is pretty much the same as forever, but 20 years, no. So we are anticipating that the shorter term leasehold lots will be provided by affordable housing providers, because it'll cost less to buy, but people who need affordable housing, they can't buy a normal lot, will at least have the security of knowing that they will live there for 20 years. They won't be moved out, they might be disabled in some way, and they just want that security of living in their own property, and that's what this will provide. The other area that it's thought to affect with leasehold strata is the places like universities, which are granted land to have the university on, and they can't sell that land by law. It has to stay with the university. They could then put up a strata, which is leasehold for 99 years, and at least have made income out of that property. So when you look at a leasehold lot for 99 years, that's not too bad. The people in Canberra build houses on 99-year leases. It's like owning your own. So it's interesting to see. We don't actually know how much of this will be taken up. The other thought is with developers, with the city expanding, very often in a subdivision out on the outskirts, they are required to put in a shopping centre. Now, that shopping centre currently is just a supermarket and a newsagent and a hairdresser. But they know that in the future this area will be a major development area and they'll want to build a garden city on it. So the possibility is that they will set up a leasehold strata scheme so that the owners of the shops in the shopping centre know they have tenure for 20, 30 years, and after that the developer will have it back and redevelop it. We don't know. It'll be interesting to see. So that's the 7 changes to the Strata Titles Act. That's an overview, so careful for the next sessions. As Graham said earlier on, we have the Strata Titles Act 1985, brackets, amended 2018. It's been amended a lot. And then in addition to that, we have the Strata Titles Act Regulations 2019, General Regulations 2019. So the Act describes what you can do, and the regs in general describe how you can do it. It's these regulations we need your feedback on. The two of them together create the law. So that's why we need feedback now. So we need you to have your say on the Strata Regulations. Now, I hope everyone's been noticing down the bottom corner there, strata.wa.gov.au. You can all repeat it after me. No, that's all right. You've learnt it. That's the website to go to. It's got the overview details there, and you probably went through the site to register for this session. It's now got the regulations, the actual 150 odd pages of regulations there, which you will have to read the sections you're interested in order to give us feedback. And we don't expect you to give us feedback on the whole thing, that would be too awful. It's just a consultation draft of the regulations. So what I would recommend, because the regulations are written like legislation, I'd recommend that you go to the Department of Justice website for their document called How to Read Legislation. You can just Google How to Read Legislation WA, and that will explain the wording in legislation for you. And the bit I like the best is the beginning of section 5, which says, most people do not read legislation for enjoyment. Really? I do, every night. Videos of this session and the detailed sessions which are coming up will be available online, as Graham mentioned earlier, and hopefully with your feedback we will absorb it all change the regs where required, and we'll have the regulations on the table in Parliament by the end of November. Okay. This is a large session. In the other sessions I did like this, we then had questions and answers, but I think it might be difficult to manage that in a session this big. So instead of that, we're having a panel of my two legal colleagues where I will pose questions which have come up in the sessions that we've done throughout the state and throughout the metropolitan area. So there are real trends in questions, what has generally been asked. So we'll go through those and get it straight from the horse's mouth, the best answers we can have. So my two colleagues, Kelly Whitfield, who's the Principal Policy Advisor for the Strata Titles Act, and Alison Fleming, who's our Senior In-House Counsel for Strata Reform. And I'm in the middle.
Is this working?
Do you want to test your... Yep.
Hello?
Is this working?
No?
No? Do you want to snuggle up to me and talk in mine? No.
Can you hear me?
Okay. I can always repeat the answers. So talking about buyer information, Kelly, I'll pose this one to you. Who's meant to provide all this new information for buyers? Is it the seller or the real estate agent? And what happens if that information isn't provided?
Okay. Oh, you can hear me. Great. Well, anytime there's somebody who's selling their lot, the responsibility to provide the information is actually on them. So they might get the real estate agent to do that on their behalf, but really the buck stops with them. There are some avoidance rights in the Strata Titles Act that the buyer can get out of the contract if certain information isn't given. So the seller should be very keenly interested in making sure that the right information is given to the seller.
Great, thank you. Dispute resolution, which is close to everyone's hearts, I know, because everyone's sort of smiling or frowning. Alison, dispute resolution, how do we know if the bylaws created over the years in our strata scheme are legal?
I think the answer is that you don't necessarily know, and Landgate certainly isn't the agency
Put your mic.
responsible. Is it working? Yep. Landgate isn't the agency responsible for determining the validity of the bylaws. So at the end of the day, if there's a question mark around the validity of a bylaw, you will need to take that issue to the State Administrative Tribunal.
Yep. Okay. Will I need a lawyer if I go to SAT?
As a lawyer, I've got to say yes. But obviously the answer is no. You don't need a lawyer. It's often prudent to have a lawyer involved, particularly if the other side has one. But SAT has a lot of information available on its website to assist non-represented persons, and you can also have persons other than a lawyer representing you. And again, this information is detailed on the SAT website. Just in relation to termination of schemes, we've also given a power for the independent advocate to represent vulnerable persons in the State Administrative Tribunal.
Thank you. So that brings us on to strata managers who will guide us in these things. Kelly, why aren't they licensed? I covered it a bit in what I said, but why aren't they licensed?
Look, we did look into the licensing of strata managers early on. One of the concerns that we've got is that it's not really that clear how many strata managers there are operating in the industry. And all licensing regimes actually have to be self-funded. That is, when you buy your licence, that actually funds the licensing regime. So if it is a very, very small number of strata managers, you could be looking at a very, very high cost for each of them to get a licence. So as Glenda was saying earlier, we're not really sure if licensing is the most appropriate response. It could really impose a lot of expense on strata owners. And this was a key concern in Parliament and one of the reasons why they didn't actually look at licensing at this stage. But what we've introduced is a lot of safeguards which are quite similar to a licensing regime in many respects. Strata managers will be required to have professional indemnity insurance to the same level as real estate agents. We're introducing education requirements, and criminal record checks must be done at least once every 3 years, which again aligns with the real estate industry. And we've really made it clear that strata companies have powers to terminate contracts if strata managers aren't keeping up with the statutory duties, the new statutory duties that are in the Act. So on the whole, we think we've struck a reasonable balance at this time, but we'll be, as Glenda said, we'll be gathering information over the years to see if licensing is an appropriate step in the future for strata managers.
That's great. And in our regional sessions, we were asked several times about volunteer strata managers. Are they still valid, and what are the requirements for them?
Right, so our definition of a volunteer strata manager must be somebody who owns a lot in the scheme. We didn't want to discourage people from having a hand in running their own scheme. Often they'll be the best strata manager of all because they've got some skin in the game. But we did want to impose some limits on how much money they can make and still be a strata manager, because we want to, again, strike that balance. If they're making it a really big part of how much money they earn, well, if you're making a professional job of it, you should get some educational requirements, you should have the professional indemnity insurance. But, yeah, we wanted to make sure that people could still have a hand in running their own scheme.
Great, thank you very much. Now we move on to leasehold. Alison's close to that one. It's close to her heart. What happens on expiry day of the leasehold scheme?
On the expiry day of the leasehold scheme, the scheme documents, your scheme notice, your scheme bylaws, your scheme plan, and your schedule of entitlement, they all cease to have effect. The certificates of title for the lots are cancelled. The land reverts to the owner of the leasehold scheme, the land and the buildings. If there is a leasehold bylaw in existence that allows compensation for improvements to the lots, then obviously the owner of the leasehold scheme is liable to pay that compensation.
Is there any ability to postpone that expiry if everybody's happy with their lease and they want to stay on?
Again, briefly, if there are leasehold bylaws in the scheme that allow for postponement of the expiry day, and that's with the agreement of the owner of the leasehold scheme and also with the approval of the Planning Commission, then yes, it's possible that the scheme may be postponed for a period of time, but for no greater period than the 99 years.